What I would do is simply collect all the facts and give them out to you folks. Walk through the timeline, walk through exactly what happened with the documentation to back it up at Edenmore, and then let you all ask questions in hopes that we actually get the facts out to people as opposed to letting what's happen now, which is that, in my opinion, with all due respect to my Democrat colleagues who are here, Mr. Spratt would rather talk about anything than his record. So what he's talking about is some supposedly wrongful real estate transaction I was involved in. Has everybody got this? Everybody got this schedule? Let's walk through exactly what happened. The first piece of property was acquired. By the way, we have documentation to back all this up. We've made copies for everybody, so at the end, if you want them, they'll be here for you to take. We have all the deeds that are referenced, all the county council minutes, the PDD ordinances, everything you could possibly imagine. As we try and lay out exactly
Mick, what we have here in paper format is about 6 or 7 copies of the deeds, where the permits were issued. The ordinances are available online, but we reference them in the timeline.
Gotcha. Okay, thank you. The ordinance here, the number. Did you get a glass of water?
I will.
We'll start in when it all started, which is back in 1999, which is when one of the companies that I work for bought the first piece of property. Why is this important? Well, you know, one of the things that you've heard is that the company that I work for flipped this piece of property. In my business, in the real estate business, to most people that entails some type of ownership for a very brief period of time. It implies that either you sold a piece of property that you had under contract but you hadn't actually purchased, or a piece of property that you might have owned for a minute or a day. Oftentimes a flip involves a closing in one room and then another closing in another room. This first piece of property was purchased in 1999. You can see that it was various parcels that were put together. Again, a flip very often entails one piece of property moving very rapidly, and that is not what happened here. We bought these pieces of property over, as you can see, about 5.5 years. The first zoning took place in July of 2002. That was PDD 8 Ordinance 504, which was at the request of the Mulvaney Properties Lancaster, which is a subsidiary, or it was at that time, of the Mulvaney Group Limited. That is my family's business, owned primarily by members of my family and members of another family. I own 3.33% of the Mulvaney Group Limited, which was the parent company that owned all of these subsidiary names that you'll see come up here. That rezoning took place as the result of 3 public hearings, one on June 3rd, one on June 17th, one on July 28th, as you can see in number 12. The zoning, which is here in Ordinance 504, laid out various land uses. And the land uses included 2,300 homes, apartments, hotel, business park, etc., town center, commercial, open space. And I believe at that time, I haven't been through it, I thought it was a fire station. At least there was some discussion about fire station. By the way, what happened there is that we knew what the northern end of the county needed. At that time, the northern end of the county needed 3 things primarily: a library, an EMS station, and a fire station. And what you'll see is sort of a fluid situation as to what sort of public improvement was going to be made as part of what was originally called St. Catherine. The ordinance 623 authorized the creation of the St. Catherine Improvement District, authorizing $30 million in bonds, first reading, second reading, and wrapping up with a third reading on October 4th, 2004. Keep up with where I am on the timeline. Let's talk a little bit about how this project, part of this development, was financed. These were Special Assessment District bonds. Special Assessment District is a creation under South Carolina law where a special tax district is created, and all of the property owners within that tax district voluntarily pay a higher level of tax. That higher level of tax is then used to finance bonds for public infrastructure improvement. For those of you who are familiar with Sun City, it is the exact same financing tool that was used to build much of the public infrastructure at Sun City, including the library. In fact, if you talk to the folks up there who live in Sun City. They're very familiar with that type of financing. There's a disclosure they get at closing. There's an amount of money they pay, etc. And we got that approved on October of 2004. There have been some allegations that I said this would be something for nothing, and I said exactly that. That is what special assessment districts are designed to be. Lancaster County, for example, received the library at Sun City for nothing. Part of the beauty of a special assessment district is that the money is allowed to be used for public infrastructure improvements and can be used to build libraries, fire stations, EMS stations, police stations. It's one of the ways in South Carolina that we make growth pay for itself. And that was the plan here when we first had the bond district created. Why was the county involved with it? The county's involved with it because under state law, only the county can create the district that will pay that extra level of tax. And then afterwards, the county will also administer the collection of that tax along with the regular property taxes that owners pay. Folks who live in Sun City, for example, pay not only the same taxes that I pay in Indian Land, but they also pay a special assessment that goes to pay off the bonds that were used to help develop Sun City. These bonds are not public. These bonds are not covered by the full faith and credit of Lancaster County. These are private bonds that are paid for solely out of the proceeds from the assessments. And if the assessments ever go into default, as I understand they have at Edenmore, now called Edenmore, the sole recourse of the bondholders is against the folks who have not paid their taxes. The full faith and credit of Lancaster County never was, nor is it, backing up these bonds. And you can check that against both your special assessment district law. I talked with the county attorney this morning, Mike at the McNair law firm. I think county council has probably spent more time than cares to think about what special assessment district bonds are. I think they're also in use in Lancaster County out at the golf course at Edgewater, and were used there to build, amongst other things, a part of the water system improvement, the tower, and other improvements out there. Again, the existing taxpayers, the regular citizens of Lancaster County, are not responsible for the repayment of those bonds. Only the owners of property within that tax district are responsible. At the time the district was created, there was one owner, which was the company for which I worked. All right. Those bonds, the $30 million bonds that Lancaster County Council approved, again, the private bonds, never sold. Never sold. They were never issued, they were never funded, and none of those $30 million bonds that were approved were ever sold. Because we sold the property. We sold the property in May of 2005 to an entity called Lawson's Bend LLC. Lawson's Bend LLC, as I understand it, was a combination of GS Carolina LLC, a company that still exists, and I believe LM Sandler, I might get the initials wrong, LM Sandler and Sons. LM Sandler and Sons at the time was the money behind this operation. They were, and as far as I know, may still be, one of the largest residential developers on the East Coast. At the time they bought this piece of property from us, they controlled over 100,000 single-family lots. They had just previous to this acquired the largest piece of property in Statesville, North Carolina history, 1,000 acres consisting of two interchanges on Interstate 77. In their arrangement they had with GS Carolina. GS Carolina was primarily, my contact was a gentleman named Tom Scott. He's the S in the GS Carolina. Tom was a long-time Charlotte area developer who had a great deal of experience. I believe he worked for the John Crosland Company for many, many years. Everything that I'm getting ready to tell you now happened after we didn't own the property. Okay? You hear a lot of allegations about how the bonds that I got approved and the subdivision that I got approved and the promises that I made, it appears not only in the ads that Mr. Spratt is running, but in a letter that a disgruntled ex-county councilman, Stanley Smith, wrote several years ago, which I imagine is the basis for a lot of what we're talking about today. One of the first things that the Lawson's Bend LLC did was go before County Council and get Ordinance 713 passed. Ordinance 713 specifically repealed Ordinance 623. Ordinance 623 is the ordinance, if you guys got your spreadsheets in front of you, Section 13 is where the zoning ordinance, which set forth the land use that I had approved for my company in October of 2004, was repealed. I'll say that again. The zoning that I had worked to get on this piece of property was repealed at the request of the new company, the new owner, and at the approval of County Council in January of 2006. That does not happen in secret, gentlemen. None of this happened in secret. In fact, by the time the story is told, the new owner will have gone before County Council no fewer than 17 times at public meetings. And that doesn't count the number of times they showed up just for informational purpose. There were no fewer than 17 public meetings before County Council announced to the press, attended by the public, by the new owner regarding the recrafting of St. Catherine into Edenmore. So Ordinance 713 is passed in January of 2006. You see that a new development agreement was agreed to in April. January. Fourth month is April. April 2006. That was the development agreement. At the same time, a new set of bonds was approved. I'm at number 17 right now. The $30 million bonds that were approved by County Council while the Mulvaney Group Limited owned this piece of property were thrown away. And a new $60 million bond issuance was approved by County Council at the request of the new owner. That was done in April of 2006. At the same time, a new tax district was also created. So what are we talking about here? We're talking about a piece of property that I had zoned in 2004. I had a property zoned in 2002 with an improvement district that was approved in 2004. And by April of 2006, the new owner had changed all of that, all of the land use. When you go back and you look at the original zoning, there was the apartments, there was the offices. The plan that we had originally had for this piece of property was going to be that it was for first-time homes. At that time, when we were working on it in 2002 through 2004, Lancaster County was primarily seen as a market for first- and second-time home buyers. We see this at Legacy Park and to a certain extent at some of the other subdivisions up there. By the time the market had gotten to where it was in 2006, the new owners believed that this was more appropriate for a higher-end, more upscale development. They dramatically reduced the density. Can't remember what the number of units was that they have approved, but it was down significantly from the 2,300. It still had commercial, it did not have any apartments, and did not have any offices. All of this was done through public hearing at the approval of County Council. 19, we sold them an additional piece of land that we had under contract. Additional readings and hearings before County Council in 2006. There's a development agreement in June of 2006, and then the declarations of covenants, conditions, and restrictions are recorded in 2006. One of the things you'll see, by the way, ladies and gentlemen, is that Stanley Smith has accused me somehow magically of not entering into a development agreement. In fact, Mr. Smith says, and this is on Mr. Spratt's website if you want to go find Mr. Smith's letter. Somehow, it says, to really understand what went wrong, you have to understand development agreements work. When a developer like Mulvaney wants to develop a piece of property and wants the county to approve bonds, the county makes that developer sign a development agreement so that if he doesn't come through on his promises, then we can hold him accountable. The county, to approve the bonds for him, the county makes that developer sign an agreement. That is a false statement. That is a false statement. Somehow Mulvaney was able to get through this process without signing a development agreement. That is an innuendo. The reason that we did not sign any development agreement is that by law the development agreement is not signed until the bonds are issued. We'd never issued any bonds on this piece of property. Only the new owner issued those bonds. And that development agreement was properly signed by the new owner and exists today on record at the Lancaster County Register of Deeds. The permits to do the work were not pulled until July and November of 2006. We never moved a piece of dirt on this piece of property. Those pictures that you see in the ad are not our work. You don't get that impression from watching that ad. It is another innuendo that Mr. Spratt is offering to the public. We did not do any of that work. The bridge that you see that is half-built, the building that you see that is partially damaged, the graffiti that you see on the skate park, we did not do any of that work because we did not own the property. This was